fairly sustained probe by police. There are a lot more examples. Single-handedly responsible for what happened in the country. And for Zubair, he says continued detention, not justified. So all these things show me that though judges have tried to be equal-handed now, but actually they were not. For example, there is a case, very celebrated case of High Court, T.T. Anthony case, which says that only one FIR can be filed for a particular offence. In case of both, multiple FIRs were fired, but when the clubbing of the cases came, Nupur was handled very, very roughly in a very, very insulting manner. But this person gets the same benefit, which was due to both of them.
Okay.
So when you say, so I would say that yes, I do not believe in harassing people of whichever side with multiple FIRs, but there are clear-cut judgments. Then why did Supreme Court make her go to courts which are not even justified? They didn't have the scope.
So I want to quote from that T.T. Anthony versus State of Kerala verdict. It was in 2001. The Supreme Court basically said that there cannot be a second FIR on the same issue. This is what the court said in that judgment, and I want to ask Aadil Boparai to weigh in on this, because this should apply even-handedly to all cases, whether your name is Nupur or your name is Zubair or your name is Arnab or your name is Rohit or Rahul. There can be no second FIR, and consequently there can be no fresh investigation on receipt of every subsequent information in respect of the same cognizable offence or the same occurrence or incident giving rise to one or more cognizable offences. Again, I keep going back to the same thing. If Zubair had put out one tweet and there are multiple cases arising out of that one tweet, the same principle should extend to Nupur as well. It was one comment made in one TV show at one place. There cannot be 9 different FIRs in 9 different places.
Zaka, in lighter vein, you would have made a good lawyer. But having said this, I'll request for 120 seconds of uninterrupted time. We welcome the order of the Honorable Supreme Court. The Supreme Court has reaffirmed the principle that there cannot be multiple FIRs arising out of the same cause of action. That's the settled law, not just in T.T. Anthony, but even consequently, it's been followed by the Supreme Court in a host of cases. But having said this, I want to highlight a critical issue which has not been raised by the previous panelists so far, which is that there has been differential, and I underline, there has been differential police action. And I will give you an illustration. You've had instances like Munawar Farooqi. You've had instances like Zubair. You've had instances like Professor Ratan Lal of the Delhi University, where the police zealously, promptly and swiftly made arrests. And on the other hand, you've had instances like the BJP spokespersons, where there has been no arrest. So doesn't this smack of double standards? Doesn't this smack of differential treatment by the executive and the police? This is point number 2. Point number 3, I completely concur with the underlying principle which was raised by the previous 2 speakers, that the process is becoming a punishment.
Yeah.
And I'm glad that the Supreme Court has intervened that yes, there should not be multiple FIRs, but at the same time, comparing Nupur Sharma and Zubair is like comparing apples with oranges. Because on one hand, you have rabble-rousers who've indulged in hate speech, who according to the government of India is the fringe element. Forget what the Congress party say. The government of India says that it is fringe element. And on the other hand, you have a fact checker who's reported hate. So therefore, you can't draw comparisons between the two. Having said
no,
this,
I'm not going into I'm not going into the merits. No, once again, Aadil, one clarification. I'm not going into the merits of either cases, either of Nupur or that of Zubair. That's for the courts to decide. But if you consider what Nupur said is hate speech, then there are umpteen tweets that Zubair has also put out which can be construed as hate speech. Ultimately, it has to be proven in a court of law. But I take your point. I take your point on the principle of arrest.
30 seconds.
Okay, 30 seconds more. Okay, 30 seconds, yeah.
Zaka, the elephant in the room, and I hope you put this question to the previous 2 speakers. Zubair was arrested for an offence which carries a sentence under 7 years. Munawar Farooqi was arrested. Similar offences. Professor Ratan Lal was arrested. Similar offences. Why the red carpet for the BJP spokespersons? Why no arrest? The protection came yesterday or day before yesterday. There was no protection for a good 1 month. Why did the police not make an arrest there and swiftly made an arrest here?
Okay.
So what's the message?
On the differential use of the threat of arrest. Okay, let me ask that. Let me ask that to a former cop. Yashovardhan Azad is on the debate tonight. The court also said today, and I want you to weigh in on this as well as what Aadil said, that the power or the threat of arrest is being used differently for different accused persons. The court upheld that the fear of arrest cannot be used as a weapon by the state, that the existence of the power of arrest must be pursued sparingly. That's what the court said today in the Zubair case, but also answer Aadil's point that in Nupur's case, she was not arrested. Although the charges against her were pending for a month and a half, she got relief yesterday from the Supreme Court, but the Delhi police took no cogent action to take her into custody, whereas in the case of Zubair, they brought him to Delhi on the pretext of one case and then arrested him for other cases. Please explain.
I totally appreciate Mr. Boparai's point that the Delhi police, though despite giving a great explanation that she was called under 41A and she cooperated, and in the case of Zubair, he didn't cooperate. But there's an important point which comes here, which the Supreme Court landmark judgment has said today, that the evidence is in public domain, and therefore perhaps there was no reason to take police remand in his case at all. So yes, on that limited point, I agree. But I would call this Supreme Court judgment a landmark judgment. I would say that this judgment really carries the stamp of Supreme Court authority for a number of things. It has set guidelines to the police and also to the lower judiciary. Look at the kind of remarks it has made and the directions it has given to disband the SIT, which gives a clear direction to the police that don't waste your time in unnecessary cases. It has also said that the person should be released by 6 p.m. That means, you forget about the tortuous process and go through electronic means and release him by 6 p.m. In many cases earlier, they were not being released on the same day. Another important point they have made, which is very, very critical, is that you can't have terms and conditions because he's a journalist and therefore no condition should apply. And the most important, going under Article 32, they have said also bail in future FIRs. So I think this is a complete judgment, and yes, it should apply equally to Nupur Sharma. A precedent has been set, and I think this is a fantastic judgment, primarily because D.Y. Chandrachud is known as a protector of fundamental rights.
But Mr. Azad, may I interrupt and ask you for a brief sort of intervention on this? You say that this will send out a massive signal to the police and to the lower judiciary. But the fact of the matter is, whether it is in Jharkhand or in UP or in Rajasthan or in Karnataka, police functions as an extension of the state. Police functions on the basis of political orders. How do you believe and why do you believe that one order by the Supreme Court will change the nature of that behavior?
You see, this fractious debate has been going on for a very, very long time. And I'm sure that the police leaders are now realizing that you just can't get away with arrests of this kind. Some of these arrests are so arbitrary, so unwarranted, and especially after Anesh Kumar guidelines and this landmark judgment by the Supreme Court, I'm sure that some of the leaders at least will stand firm. And I hope even state governments will appreciate that they have to follow some norms and some rules.
Okay, let me ask Swapnil Kothari. A few days ago, we had no less than the Chief Justice of India famously say that in India, the process, unfortunately, has become the punishment. And I can't cite two better examples in recent times, whether it's Nupur Sharma or Mohammed Zubair, where clearly the process had become the punishment. So I want to ask if that has been upheld today by the Supreme Court in the Zubair matter, where it said that seemingly he was being made to run around,